Criminal law, the law of theft. The Theft Act 1968. The offense of theft is set out in Section 1(1). This provides that a person is guilty of theft if they dishonestly appropriate property belonging to another with the intention to permanently deprive the other of it. The actus reus of theft consists of 1. Appropriation, 2. Of property, 3. Belonging to another. The mens rea consists of 1. Dishonesty, 2. Intention to permanently deprive. Appropriation is defined in Section 3(1) as including any assumption of the rights of an owner. The phrase, assumption of the rights of an owner, does not mean that the defendant actually acquires rights of ownership, rather it means that the defendant seeks to assert those rights. That is, they deal with the property as if they were the owner. This could be where they take possession of it, or offer it for sale, destroy it, change the appearance or hire out the property. For an appropriation to take place, there is no requirement that all the rights of an owner are assumed. One right is sufficient. This was established in R.V. Morris, where the defendant switched labels in a supermarket. This was sufficient to amount to an appropriation. An appropriation may still be present notwithstanding the consent of the owner. In Lawrence v. MPC, it was held that an appropriation had taken place where the victim handed his wallet to the defendant taxi driver and told him to take out the money. Property is defined in Section 4(1). Property includes 1. Money and all other property. 2. Real property. 3. Personal property. 4. Things in action. And 5. Intangible property. Money includes notes and coins. A person appropriating money must intend to return the exact same notes and coins to avoid liability. In R.V. Vielemol, a company director borrowed money from the safe. He was liable as he intended to replace the notes rather than give back the same ones. Real property refers to land and anything fixed to land. This includes houses and buildings. However, by virtue of Section 4(2), land cannot generally be stolen unless it's a fixture or the defendant is a trustee and acts in breach of trust. Personal property refers to property other than land. This includes prohibited drugs as established in R.V. Smith. The case of R.V. Sharp held that property does not include corpses, although in R.V. Kelly it was held that body parts conserved for scientific purposes may constitute property. In R.V. Welsh it was held that a urine sample did constitute property and it did not belong to the person who had provided the sample. The defendant was liable for stealing his own urine. Things in action refers to a personal property right which can be legally enforced. This includes a patent right, a debt, a right arising under a trust, and a right to overdraw an account. Intangible property is property which has no physical existence, such as an export quota. However, it has been held that confidential information does not constitute property. In Oxford v. Moss, the defendant stole an exam paper, copied it and returned it. He was not liable for theft of the confidential information. Section 4(3) provides that a person who picks wild mushrooms, flowers, or foliage growing wild on any land will not be liable for theft unless it is for sale or reward. Section 4(4) provides that wild creatures cannot be stolen unless they have been reduced into possession by or on behalf of another or are in the process of being reduced into possession. Section 5(1) provides that property will be regarded as belonging to any person having possession or control of it. This can mean that a person may be liable for theft of their own property. For example, in R.V. Turner, number 2, the defendant was liable for stealing his own car when he took it back from the service station without paying for the repairs. Section 5(3) provides that where the property in question is given to a person with instructions to deal with it in a certain way, the ownership in the property is deemed to remain with the giver. Therefore, if a person receiving the property deals with it in a way which is inconsistent with the instructions, this can amount to theft. In Davidge v. Bennett, the defendant was liable when she received money from her flatmates to pay the gas bill and she spent it on Christmas presents. Section 5(4) provides that where a person receives property by mistake and is under an obligation to return the property, a failure to restore the property will amount to theft. In AG Ref. Number 1 of 1983, the defendant's employer made a mistake in calculating her wages and she received an extra amount in her bank account. She noticed the extra money, but did nothing. She did not spend it, nor did she tell the employer or return it. The Court of Appeal held this was sufficient to incur liability for theft. If property is truly abandoned, it has no owner and anyone who takes it will not be liable for theft. Difficulty may arise in deciding whether property is abandoned. In Ricketts v. Basildon Magistrates, items left outside a charity shop were deemed to belong to the donor and not abandoned. Lost property is still regarded as belonging to the loser. However, where the owner cannot be found by taking reasonable steps, the finder of the property has better title to the items than the owner of land on which the items are found. In Bridges v. Hawksworth, the claimant found some money on the defendant's shop floor. He was entitled to keep it when the owner could not be found. However, where the items are found under the surface of land, the landowner has a better title than the finder. In Waverley Borough Council v. Fletcher, the council were entitled to the items discovered by the defendant with his metal detector. There is no statutory definition of dishonesty. Section 2(1) gives 3 instances of when a person is not to be regarded as dishonest. Section 2(1) if he appropriates the property in the belief that he has in law the right to deprive the other of it, or Section 2(1)(b), if he appropriates the property in the belief that he would have the other's consent, or Section 2(1)(c). If he appropriates the property in the belief that the owner cannot be found by taking reasonable steps. These 3 exceptions are judged entirely subjectively. There is no requirement that the defendant's belief is reasonably held. This was seen in R.V. Holden. The defendant worked for QuickFit. He took some second-hand tires. He had seen other workers take them and thought it was allowed. His contract of employment stated it was forbidden. The court held he was not dishonest. He believed he was allowed to take them. It didn't matter what was stated in his employment contract or whether his belief was reasonable. Similarly, in R.V. Small, the defendant was not dishonest when he believed the owner of the car could not be found. It was irrelevant that a reasonable person would know that you could trace the owner through DVLA. Section 2(2) states that a person may be dishonest notwithstanding a willingness to pay. This is unhelpful in determining honesty since it does not state whether a person will be honest or not, but simply may. The case of R.V. Feely established that the question of dishonesty must be left for the jury to decide. In situations not covered by Section 2, where the defendant claims they are not dishonest, the Ivy test applies. The jury must decide whether the defendant's actions were dishonest according to the ordinary standards of reasonably honest people. Under Section 6(1), a person is treated as having the necessary intention if they treat the property as their own to dispose of regardless of the owner's rights. In R.V. Lavender, the defendant took some doors from a council property due for demolition and installed them in his girlfriend's council flat. The court held he had treated the doors as his own regardless of the council's rights. Section 6(1) also covers borrowing in circumstances making it equivalent to an outright taking. The courts have taken a strict line on what amounts to being equivalent to an outright taking. In R.V. Lloyd, Bowie and Alley, the court held this required all the virtue, goodness and practical value to be taken from the goods. The defendants were not liable since they returned the films in the same condition they had taken them. In summary, the Theft Act 1968, Section 1 defines theft as, a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. Section 2 considers dishonesty. Section 3 defines appropriation. Section 4 defines property. Section 5 defines belonging to another. Section 6 defines intention to permanently deprive. Section 7 sets the maximum penalty of 7 years. Please subscribe to our YouTube channel, it's free to do so and will help us to keep providing these videos. Thanks for watching.